Just making sure. Okay, great. And Alex, just let me know when the trickling in stops, and we will, and then we'll go from there.
I think we're all set, please.
All right, fantastic. Well, good afternoon. I am Blaise Bryant, the Communications Specialist with the New York Association on Independent Living, NYAIL, or as we so often say in the space, NIL. Thank you so much for joining us for the July webinar in our 2024 webinar series, the ADA and New York State Human Rights Law. They intersect and where they are different. Before I introduce our presenter, just a couple of logistical things. Number one, the webinar is being recorded. Number two, the slides will be made available after the webinar. I will send them to you both in the email with the recording, and they will also be posted on our website, which is ILNY, which stands for Independent Living New York.org, under the training and education section. The chat, and this is the final logistic number 3, the chat is disabled for screen reader accessibility accommodations. You can put your questions in the Q&A box. Again, please just try and refrain from the questions of whether the webinar will be recorded and the slides being available, because both will happen. So let's get this show on the road. I'm glad to introduce someone who I gladly referred to as a wonderful resource and friend in the disability rights community, someone who exemplifies disability pride through their work, and that is John Herrion, who is the Director of Disability Rights with the New York State Division of Human Rights. John, thank you so much for being very generous with your time. The floor is yours.
Thanks so much, Blaise. It's really a great privilege and honor to be with all of you today. Thank you so much, Blaise, for the opportunity, especially during the important month of July, as we celebrate the anniversary of the passage of the Americans with Disabilities Act. And it's a perfect topic. It's a subject that I often get asked about. You know, people tend to be more familiar with the Americans with Disabilities Act, you know, as a federal law, as the premier piece of civil rights legislation that protects people with disabilities across the country and here in New York State. Sometimes the New York State Human Rights Law gets overlooked a bit. And this is an opportunity to share some of the distinctions, you know, maybe some of the advantages that exist in relying on the New York State Human Rights Law to ensure that covered entities know their obligations under the law, you know, that employers know what their obligations are, housing providers and owners of businesses and places that are open to the public, for all of them to, you know, all of them may have a familiarity with the Americans with Disabilities Act, but not quite so much with the New York State Human Rights Law.
John, excuse me, I got to stop you for just a second.
Okay.
I got a message that the captions are not working. I just want to make sure everything is working fine before you continue.
Okay, let me know when I should proceed.
Sarah, are you able to confirm everything's working as they should be?
I see them appearing on my screen.
Okay. Okay, great. And can I just have one other panelist confirm that they're showing up on the screen? Because if they're showing up for you, then they're showing up for the attendees. At least I would think. Alex, how are they showing up for you?
So I think Mark is looking for a different accommodation than just the captioning.
Okay. Yeah, Mark, our captions are done live, and if you need an added accommodation, the video, the recording will also be captioned as well. So I apologize. Get in touch with me afterward so we can figure out how to do better. Okay. All right. With all that, John, apologies. Carry on.
Yeah, no worries, no worries. Hoping everybody can access the program. Just circling back to where I was in talking about having knowledge and understanding of the provisions of the New York State Human Rights Law, being that we're here in New York State, certainly has its advantages. And again, I'm really happy to be with this audience, with this group, as I usually am. Folks who know me and have heard me speak before. I like to tell the story that I got started back in 1990, the summer of 1992. It was at the Rockland County Independent Living Center, and the Americans with Disabilities Act had more or less just been passed, and it was kind of an exciting opportunity as a law student to get involved in an area. I knew I wanted to do public interest work and civil rights work. And here before me was this new law with so much promise, some of it yet to be realized, but also the terrific opportunity I had, at the local independent living center there in Rockland County, because the thing I valued most and the thing I always come away with to this day is the peer support. Seeing people with disabilities assist other people with disabilities, really to me is invaluable, and could see it in a variety of ways. Somebody who's having a hard time looking for a job might have come into the center in a wheelchair, and just seeing that there was another person on the other side of the desk in a wheelchair having a job, I think, promised hope there too. And recreational opportunities for families with children with disabilities that were shared. Come to the local wheelchair tennis clinic or wheelchair basketball clinic. I've seen sled hockey. I've been to Long Beach where there were blind surf instructors teaching other blind persons how to surf. They were all up on surfboards. I probably could not myself have gotten up on the surfboard, but they were having quite the time. And it was just, I've always appreciated that peer aspect that independent living centers live up to, as well as to the value that they have in their communities. So always happy to be with you all, and we'll get into the substance of the material here. I'm going to share my screen. Let's see here. This slide should be here. Okay, so the slides are up. Alex, could you just confirm for me that you can see them and they're moving the way they should be?
Yep, they look good.
Great, thank you, Alex. Okay, so as discussed this afternoon, we're going to be talking about the Americans with Disabilities Act and the New York State Human Rights Law. What I'm planning to cover are some of the comparisons and contrasts between the two laws. Talk about some of the distinctions that exist in some of the statutory provisions, distinctions in who's covered, distinctions in how the laws are enforced. And then, one of the roles I remember playing early on in my experience as independent living center, and still play it to some extent, is, where should I go with my complaint? I feel like I've been discriminated against, and I want to have that remedied. I want to have that problem fixed. Where should I go? So I'm hoping with some of the information I share today, we'll have some answers for that. So I'm just going to start with the real basics here, and the Americans with Disabilities Act, as many of you know, is a federal law. It primarily covers employment, state and local government entities, and places of public accommodation. New York State Human Rights Law is our New York Human Rights Law, and that primarily covers employment, places of public accommodation, including state and local government entities, and housing. So that's probably one of the major distinctions off the bat, is that you have protections under the state human rights law focused on housing. And there are some distinctions with the Federal Fair Housing Act that I'll talk about in a bit, but that's a major distinction. Another few pieces on the New York State Human Rights Law before we get into it. It was the first, a little bit of a history lesson anyway. It was the first human rights law passed in the United States, first state in the country to pass a human rights law. So I've been with the Division of Human Rights for 16 years now. Prior to that, I worked at Eastern Paralyzed Veterans Association and United Spinal Association with some people I'm sure you'll know, Jim Weissman and Cleo King. And in 2008, March 2008, I took a position here with the Division of Human Rights. And, say what you want about the state of New York. It was the first state in the country, as I say, to pass a human rights law. And since I've been here, I'm always happy to share that I've only seen the law added to or clarified in ways that civil rights for persons with disabilities and for persons in other protected classes, have been improved, not diminished. And, in today's day and age, there are other states in this country where that's not the reality. Civil rights in different ways are being diminished in other states. So I'm happy to be a resident of New York State. I'm happy to be working for the agency that enforces the state's human rights law. And again, as I say, I've only ever seen it added to, never really diminished. So first piece of information here, this is probably one of the biggest takeaways I like to share with folks, is the distinction of the definition of disability. Who's covered under the New York State Human Rights Law. So the slide here includes statutory information. It's from the statute, and it talks about disability being defined as a physical, mental, or medical impairment that results from any number of medical conditions or health conditions that prevents the exercise of a normal bodily function or is demonstrable by a medically accepted clinical or laboratory diagnostic technique. We can look at records of impairments or even conditions regarded by others as impairments. So very broad definition of disability here. And in a few slides, I'm going to get to the definition of disability under the ADA. One of the things I realized early on in practicing in this area was attorneys typically will look at cases, what have other courts decided, if a complaint has been filed under the ADA, maybe it's an employment discrimination complaint, maybe it's a refusal to reasonably accommodate, how did the court with that set of facts come to a conclusion, come to a finding? Will it help my case? Can I rely on the findings of another court with a similar set of facts that applied the law, in a way that's going to help my client? And in a lot of the ADA cases, and I know the ADA was amended, 2010, maybe was it? I don't remember the year, but a lot of the cases, the ADA claim was kicked out. The court would kick the ADA, the federal claim out, saying that the person wasn't disabled enough to meet the statutory definition of disability under the Americans with Disabilities Act, but they permitted the state claim to move forward. So it wasn't, a full dismissal. It wasn't a complete loss for the plaintiff, although their ADA claims were dismissed. They were able to continue to proceed under the state human rights law. And what that demonstrated to me was there is a reality in proceeding solely with an ADA claim that could result in a real problem for people with disabilities or with plaintiffs. And indeed, if I remember the statistic correctly, it was a significant percentage of cases that were bought, employment cases that were bought under the Americans with Disabilities Act, that were dismissed. And they were dismissed from a legal standpoint. They call it a motion for summary judgment. And that means you don't even get to a hearing. There's no testimony or cross-examination. The judge basically decides the case on the papers. And, there's an economy of resources there to get it done that way, so as not to take up the court's time or the party's time. But the reality that was being realized was that a lot of these cases were being dismissed under the Americans with Disabilities Act because plaintiffs weren't considered disabled enough to be protected by the law. And there was a lot of really compelling testimony. I remember, when the ADA was amended and there was language added to expand on the definition of disability, right? You can't take, ameliorative effects or like medications, reading glasses, different things you would do to diminish the impact of the disability on you couldn't be taken into consideration. And I think episodic disabilities were also considered. So there were some opening, of the gate in terms of who could get in, but really never, I don't think the spirit of the law was truly met there in some of these cases early on. So, again, that brings me back to the importance if you're working with somebody and maybe there's a question as to, does the disability substantially limit a major life activity? We don't get hung up on that. You don't see that language there on the slide here. It talks about physical, mental, or medical impairments, talks about a record of impairments or being regarded as having an impairment. So we don't get into those qualifiers. And I'll run the ADA slide by you in a moment. But just one or two other things I wanted to touch on here. That record of an impairment, I saw that one realized a while back when I was at a program. It was World AIDS Day. New York State Department of Health AIDS Institute was doing a program up in Albany. And they had a number of young adults who were presenting. They were doing a panel, I should say. And they had all been born HIV positive. They were all born with the virus. And they were in their, young adults, early 20s, most of them. And, a large chunk of the presentation was how healthy they were. They were taking the prescribed medications. It had really either diminished or eliminated the virus, from their bodies. But they still had this, this diagnosis. Were it to be disclosed, or had it been disclosed, I should say, they shared some pretty tough stories of harassment and abuse and discrimination. And again, that to me fits into this bullet here, right? You may not be somebody whose conditions are manifesting, right? The symptoms are manifesting. It can be that you were born HIV positive, you have a record of an impairment, and then somewhere down the road there's a disclosure, and you continue to experience that discrimination or harassment, and that's against the law. And then we don't see a lot of these, but they do come in, and this again would be, if you are regarded, if somebody perceives you to have a disability and takes an adverse action against you based on that perception, they don't get to say, oh, you're not protected by the law, you don't have a disability. No. And these prongs are also in the ADA, these two here. But the idea there being that if somebody perceives you as having a disability and then takes an adverse action based on that perception, they can't say, oh, you don't have a disability, you're not covered by the law. We have this coverage here, which also exists in the ADA as well. Just wanted also to share that under the New York State Human Rights Law, temporary disabilities are explicitly covered. So any type of, maybe it's a broken leg or some type of temporary condition that's manifesting itself and the employee needs a reasonable accommodation. We're not, somebody with a broken leg, we're not talking about, building out an accessible bathroom facility necessarily or installing a ramp. Typically, it's more minimal in terms of accommodations, time away from the job to heal, or maybe a modified work schedule to heal that condition. But again, it speaks to the generosity and the broadness of how how disability is defined under the law. That temporary disabilities also are covered under the New York State Human Rights Law. This was where I wanted to set forth the distinction with the definition of disability under the ADA. So the Americans with Disabilities Act defines disability as a substantial limitation of a major life activity. So again, those qualifiers are there, right? We don't see those qualifiers in the earlier slide. There's no mention of it being substantial. You know, it relates just about every health condition somebody could have, anatomical, physiological, genetic, or neurological. But no mention of major life activities either. So those thresholds don't have to be met. So again, if you're working with somebody and there's a question, is the disability substantial? Does it substantially limit a major life activity? Are we talking about a major life activity here? It may be more prudent to file a claim with the New York State Division of Human Rights under the New York State Human Rights Law. Rather than, people won't say, oh, I want to make a federal case out of this. Well, that's fine, but you may be starting at some peril there if you don't meet the definition. And you don't want to get kicked out on jurisdiction, because then, if the court is saying, sorry, you're not protected as a person with a disability, you don't get to the rest of the case. You don't get to the merits of the case. So what I like to say here at the Division of Human Rights, we don't get hung up on how disabled someone is. We can more so focus on whether or not discrimination took place. And I think that's where the focus should be. So employment, I want to talk a little bit about employment. Close to 90, I think it's 85% the last time I looked, of all the complaints filed with the Division of Human Rights are cases against employers or prospective employers. Roughly a third of those cases are complaints that include allegations of discrimination based on disability. So disability and race really run kind of neck and neck in terms of the types of complaints that we get. And here, really the employment provisions do mirror one another very largely. If you looked at the provisions in Title I of the ADA and compared them to the provisions in Section 296 of the Human Rights Law, you'd see they look pretty identical. Another major distinction here, though, is how are employers covered? ADA covers employers with 15 or more employees, while the New York State Human Rights Law covers all employers. And this was a distinction that was made a couple of years ago. The agency was getting complaints, not so much in the way of disability, but in the way of harassment, sexual harassment, other types of discrimination from people that were like like domestic workers. And typically it was one domestic worker, maybe they provided care for the child in the family, and they were experiencing discrimination or sexual harassment, some really bad things. And previously, the New York State Human Rights Law could only cover employers with 4 or more employees. And so they were able to get those charges dismissed, and the legislature amended the state human rights law to say, if you have 1 or more employee, you're covered. So all employers under the state human rights law are covered. So that begs a question, right? If you're working with somebody and they maybe work for a smaller employer, you got less than 15, you want to be filing that complaint under the New York State Human Rights Law with the Division of Human Rights. So a little bit about the enforcement agencies, for employment. So the Equal Employment Opportunities Commission, the EEOC, under the Americans with Disabilities Act, Title I complaints there have to first be filed with the EEOC. So it's legally, they call it exhausting your administrative remedies. And that was written into the Americans with Disabilities Act. And we have a contract, the Division of Human Rights has a contract with the EEOC. So sometimes complaints get filed there, we'll get transferred over. We consider them dual filed, and we'll look at them under our law. I don't know that we have control over EEOC's discretion on that. And if you do have a complaint filed with or somebody you're working with has an EEOC complaint pending, you'll want to let us know. That way we can, once the complaint comes to us, if they're trying to go to both agencies, sometimes that happens. People want to file in both places. We can entered as a duly filed complaint. That helps with our relationship with the EEOC, our partnership with the EEOC. So after that complaint gets filed with the EEOC, EEOC may take like a pattern or practice type case of discrimination, which may help you as being part of the discrimination, being one of the parties therein. But otherwise, it's a right to sue letter, which really is kind of the ticket to get into federal court. So there's no, oftentimes the ones I've seen anyway don't, decide either way really, and don't offer any remedies other than to go into federal court. And again, these are employment claims that are filed under Title I of the ADA. At the same time, or alternately, people can file directly with the Division of Human Rights. And that is not to await a right to sue letter in state court or federal court. That is to have your claim investigated and, if necessary, prosecuted and adjudicated, here at the Division of Human Rights. So listen, if you bring in a federal claim under the ADA, I understand all the protections that are associated therewith, but you do have to, jump through that hurdle first with the EEOC and wait for that right to sue letter. Once you file with us, an investigator will get assigned, and the investigation will be underway. And as I say, if we make a probable cause determination finding, the case will get assigned to an attorney. That right to sue letter puts you in federal court. You probably should have a lawyer there. There's going to be a filing fee, when you file papers in federal court. Not the case at the Division of Human Rights. You can file without an attorney. It's easy to file complaints. I have a slide later about how to do so. And you don't need a lawyer, and you don't need to pay a filing fee. We have a prosecutions unit that's staffed with attorneys who prosecutes these cases. So some people do come with private counsel, which is fine, but otherwise an attorney will be assigned to the case. A little bit about statute of limitations. So statute of limitations is how much time do I have to file my claim? Under the ADA, you have within 180 days. Here in New York State, there is a similar state anti-discrimination law. So that allows up to 300 days to file the claim. Our statute of limitations was recently amended. So I want to take us through that a little bit. So this happened this year. February 15th, 2024 is the date we look at. So as complaints come in, one of the things our intake folk are looking at is what is the date of the alleged discrimination, right? Before February 15th, 2024, you had up to 1 year to file the complaint with our agency. You could go into state court with your claim if you missed that 1 year window, and you had up to 3 years to go into state court. You can't do both. You can't file both with New York State Supreme Court and New York State Division of Human Rights. But if, let's just say you realized, 2 years ago I lost a job or I wasn't hired, and I think it was because of discrimination, you could go into state court if you missed the 1 year window of the Division of Human Rights. Excuse me. So that all changed. That'll change this year. And the legislature made it 3 years to bring the claim here, as well as if you wanted to go alternatively, not at the same time, but alternatively in state court. So when we look at that date, if it's something that's happened on or after February 15th, 2024, we can now go 3 years. Okay. So if you were fired, let's say on February 16th, 2024, you have up to February 16th, 2027 to file that claim here with the agency. So we've extended the statute of limitations there. I want to talk a little bit about retaliation. This is I always want to emphasize this piece, both in our law and in the ADA here this afternoon today, because I think it really is an important element of the statute. People don't oftentimes understand. And I think it also is an area where, folks like yourselves who work at ILCs around the state invariably will run into people who don't want to file a complaint because they are fearful that a bad situation will be made worse, right? the situation at the job is already terrible. I don't want to make it worse. I don't want to file a complaint against my landlord because I'm fearful, that I'll get evicted. So under both the ADA and the New York State Human Rights Law, retaliation is unlawful. So here under the ADA, it says retaliation is when an employer takes a negative action against an employee or applicant with a disability because they are exercising their rights. And this includes requesting reasonable accommodation, right? So if you request a reasonable accommodation under the ADA and the employer throws their arms up and says, "I've had it with you, you're fired," you have two colorable claims, right? One would be refusal to provide the reasonable accommodation, and the other would be retaliation. And under the ADA, it's a form of discrimination under all three titles. So employment, government, state and local government entities can't retaliate against you, and neither can places of public accommodation. Same can be said about the state human rights law. So I was just having this conversation earlier today and talking about understanding what is retaliation. So typically when we get our complaints filed at the division, retaliation is a box that gets checked. And I think it's because people think, because I have a disability, I was retaliated against when my reasonable accommodation request was denied, or when I didn't get the promotion or I didn't get the job, that was retaliation. That's really discrimination, and that's against the law. But retaliation is something a little bit different. And I think it's important to focus on when you're trying to assist somebody kind of work through that anxiety of whether they should file the complaint or not. So let's talk about what it is. So what it is it's unlawful for any of the covered entities, so employers, housing providers, places that are open to the public, to retaliate against somebody because that person has opposed any practice, any type of discrimination forbidden under the New York State Human Rights Law, or because that individual has filed a complaint, testified, or assisted in any proceeding under the State Human Rights Law. So one of the things I like to share here is, if you file, and people will ask, can I file the complaint anonymously? And the answer typically is no. The complaint has to be served on the respondent, and we are demanding a written response to the allegations in the complaint. So they need to know who is it that is saying they were denied an accommodation or didn't get a job opportunity here because of their disability, because we're going to ask for information that's pertinent and relevant to that individual, right? Hard to do if it's anonymous. So for purposes of retaliation, the thing I like to share with folks is that even if the underlying claim falls apart, right? Let's say, the accommodation you were asking for wasn't reasonable. It wasn't going to be effective in allowing you to get the job done. In all honesty, after we investigated the matter, you really weren't qualified for this job. They did choose a qualified candidate. They didn't engage in any unlawful conduct. But let's keep in the reasonable accommodation context. But once they got the complaint and they fired you over it, or they, cut your hours or your pay, that's retaliation. So even if the underlying claim falls apart, we can put, covered entities, employers, housing providers, et cetera, on the hook for that unlawful retaliation. So that's a level of protection I think is helpful for people to understand, because even if the underlying claim doesn't have merit, you're still protected from what you're worried about, right? I'm worried about making a bad situation worse. I'm worried about my landlord evicting me. I'm worried about my doctor not providing care for me anymore. This is another area, that I've had a lot of discussions with different advocates about, a very serious area where access to healthcare for people with disabilities is either compromised or accommodations aren't provided. And it literally can result in life or death situations. And people are just so reluctant to file against their doctors. They don't want to create an adversarial relationship. And sometimes you can say, well, just go find another doctor. But a lot of times it might be a rural community, it might be a specialist, right? It's not quite so easy. So sharing this information, I think, is really important with folks so that they understand that they do have protections under the law against retaliation. Sticking with employment, reasonable accommodation. So again, here the provisions are largely the same under both the ADA and the state human rights law. One change to the New York State Human Rights Law was the addition of pregnancy-related condition. That was added a couple of years ago, and the idea there was to clarify that folks with pregnancy-related medical conditions are also entitled to reasonable accommodation under the human rights law. Employers couldn't just say, you know what, you're pregnant, take the next 9 months off and we'll see you when you come back. That's okay if it's with pay, but a lot of times it's not. And a lot of times people want to continue to work, or they're able to continue to work. So just saying because you're pregnant, don't show up, or use your leave, right? Exhaust all your leave. Well, I don't want to do that. I need to have leave after I have my baby, is something that it probably was the impetus for having this change made. I have a few more slides on the interactive process, and then I'll open it up for questions before we move into another area. So interactive process is a very helpful feature found in both laws. There are some distinctions. I, as somebody who works for the Division of Human Rights, actually like the way the EEOC actually lays it out a bit better than the way it exists in our regulations. But I have no pride in authorship over either. Under the EEOC, you can see here, the interactive process requires an analysis of the particular job involved and determining its purpose and essential functions. And again, this is recommendations for the employer, right? The employer to consult with the person with a disability to ascertain the precise job limitations imposed by the individual's disability and how those limitations can be overcome with a reasonable accommodation. Also require the employer, in consultation with the person with a disability, to identify potential accommodations and assess the effectiveness. That's an important word in our regs too, right? This accommodation needs to be effective in allowing the person to do the essential functions of the position. And then there is some consideration here, right? The preference of the person to be accommodated and select and implement the accommodation that's most appropriate for both the employer and the employee. So I like how the EEOC lays that out. Couple of slides here that I'm going to share with you is the interactive process under the state human rights law. And the thing about the interactive process I like is hopefully it keeps the complaint from being filed, because hopefully it's resulted in what it's designed to do. It's designed to have the employer and the employee interact with one another so that they can hopefully, land on an accommodation that's reasonable for the employer, but also effective in allowing the employee to do the job that they are required to do. So employer should be providing information to applicants and new employees as to their rights about reasonable accommodation and disability. Whenever I do presentations for employers, I always emphasize how smart it is to have a reasonable accommodation policy. If you have a time and attendance policy, policies about appropriate behavior in the workplace, expectation setting, et cetera, have a reasonable accommodation policy, and make sure your HR managers know what it is, because a lot of the cases that we get filed here, the complainant went to their supervisor, and the supervisor doesn't know anything about the New York State Human Rights Law or the ADA, and they deny the accommodation out of hand, typically saying, well, if I do this for you, I'll have to do it for everybody else. I can't change your hours, and that's unlawful. It's against the law. And so when I'm working with employers, I'm always saying you don't want to find yourself in that situation, having to respond to a complaint. So have a policy that you share with your employees. We also get a lot of complaints when the employer is not moving forward quickly enough, right, to consider the accommodation. So once we get that complaint, we're going to ask the employer, what have you been doing with this? Have you been sitting on it? Is that resulting in an effective denial of the accommodation? Or have you been exercising good faith? Have you been clearly requesting information from the applicant or the employee on the documentation that's needed? And then, there is a right to medical documentation and information. So if you're working with somebody and they're concerned or really don't, it usually comes under the guise of a couple of things, right? One is, my performance at work has been diminishing since I've been diagnosed with XYZ, or since I had the accident, or my impairment has been manifesting itself, and my employer is starting to call me out on it, right? That my performance is dropping, and I really don't, I'm really concerned about sharing with the employer what my condition is, what my needs are. When that type of conversation is happening, you want to share with that employee, hey, the rights to accommodation attach once you ask the employer once you let the employer know that you have a disability and that you're asking for an accommodation in order for the barriers that the disability is causing to be removed or diminished so that you can keep working there. And in fact, you have a legal right to those accommodations. So those only attach when you let the employer know that there's a need for it. Particularly if it's an invisible disability, you want to be able to put that on the table. And remember, we have, under the New York, again, another distinction here that brings me back to the generosity of the definition of disability under the state human rights law is that we don't, if an employer is saying, I'm not going to give you the accommodation unless I know what your diagnosis is, no, because under the state human rights law, we talk about conditions and symptoms related to the condition. So it can be, these are the conditions I'm getting, these are the symptoms I'm being treated for, and this is the accommodation I need in order to continue to be able to do my job. Important piece here, the last piece is the employer must maintain the confidentiality, right, of person's medical information. And here, a little different than the ADA, because it says the employer has the right to select which reasonable accommodation will be provided. So long, and again, under the human rights law, we're looking at effectiveness, right? So if there's some disagreement, the employee is saying, well, this is the accommodation I want. At the end of the day, we're looking to see which one is effective. Employee has the duty, we said this earlier, about the duty to make the disability and need for accommodation known to the employer, and always has the right to request an accommodation, even if the medical condition is not changed. That's also in the reg. So now we're talking more about the employee's duties. Okay, a lot of times in the complaints that we get, our investigators start to ask questions. We want to know, again, this is under the New York State Human Rights Law. Has the employee been cooperative with the employer, in providing information related to the requested accommodation? Have they provided medical information that's been asked for? And again, if you're working with somebody, well, I don't want to be sharing all this medical information, it's private to me, understandable. But there is an obligation that the employee has to keep that medical information confidential. And indeed, this information should be kept aside and apart from any type of personnel file in order to keep it confidential. I'm going to stop here for a moment or two. If there's any questions, Blaze or Alex, I'm not sure how you want to, if there are any questions in the Q&A, and then maybe we can answer a couple and I can move on.
Sure. Yes, we have some questions in the Q&A, which Alex will read out for access purposes, and this would be the time for you to put your questions in the Q&A box, as we have about 15 minutes left before we need to wrap up.
First question comes from Aaron. If I have a client who's experiencing blatant discrimination, should we go through EEOC before DOJ civil rights, based on what you said earlier?
Repeat the question one more time, Alex. I'm sorry, I missed a little.
If I have a client who's experiencing blatant discrimination, should we go through EEOC before DOJ civil rights, based on what you said? I'm assuming this is employment.
Right. So DOJ, Department of Justice, would be like for public accommodation, Title II and Title III. EEOC would be Title I. So to answer your question, you do not have to for purposes of coming to the Division of Human Rights. And if you want, I'm going to share my information at the end of the slide presentation, if you want to contact me directly so that we can hash it out a bit more. But there's no requirement that you go to EEOC first or you file with Department of Justice first before you come to the Division of Human Rights. You just can't do both. That's the biggest. You can't do both at the same time.
Okay. The next question from Maria. Under employment, how does the New York State Human Rights Law protect independent contractors?
So they are considered as employers under the state human rights law. We have some case law on that. I'd be happy to share it with you. But independent contractors do not get out from their obligations as employers under the New York State Human Rights Law.
I think Maria might have been asking, so if you are working as an independent contractor of
you are considered an employee. So whoever you have that contract with, you are considered an employee of that employer, and that employer has all of the obligations we've just went through.
Thanks, John. This is for Max. How does DHR handle cases where the state claims sovereign immunity from ADA or other federal acts? Are there examples of court cases advancing under the New York State Human Rights Law when this happens?
No cases that I'm aware of, and I know that this has been an issue advocates have been trying to achieve in the legislature since I was back in my day an advocate, also trying to achieve it. What I'll say is that the state human rights law in many ways covers state and local governments, covers employers, private and state and government employers, places that are open to the public, including government entities, in a lot of the same ways the ADA does. So you can sue a New York State employer for discrimination under the human rights law for, discriminating against you based upon your disability. You can sue, the Department of Motor Vehicles if they fail to provide you with an accommodation under the New York State human rights law. So while I understand the push for the waiver of the sovereign immunity for ADA claims, I think a lot of the remedies are available under the state human rights law in a similar way that they're available under the ADA presently.
So just to follow up on that, John, I guess what you're saying is that the state can't really escape their obligations under current human rights law.
I think it's smarter to file under the state human rights law. I think a lot of the protections, as I've gone through today, and we have a couple more slides to go, but a lot of them mirror what the ADA would provide and mirror who's covered as well. So I think if you're proceeding under the ADA in itself, this waiver of sovereign immunity does come up. But if you file a complaint under the New York State human rights law, most, if not all, the protections that are available under the ADA are also available under the state human rights law.
Great. The next question is from Mariah. Any advice for employees that have been made to feel like a burden or that are asking too much and getting uncomfortable feelings at work for requesting hour changes? Is it different for part-time versus full-time job situations?
Yeah, there's no distinction between part-timers and full-timers. This covers employees, so there's no distinction there. And if you feel like it's at a point where you're being made to feel so uncomfortable as that I shouldn't even be asking, I think you're effectively being denied that accommodation request. You can file an individual complaint. You can reach out to me. We also have a division-initiated investigations unit. So that's a unit dedicated to pattern and practice type discrimination. So if it's, a big employer in the community and they are handling themselves in a way that makes employees feel uncomfortable, or there's a chilling effect on employees who are asking for reasonable accommodations, we'd like to know about it.
Great. The next question is from Shirley. Is there an aspect of New York State human rights law that helps to provide stronger or more effective rights for people with disabilities than the ADA, but this is related to accessing healthcare?
I think they're identical. I think that under the state human rights law, what I like about people say, well, it's not explicitly there, and I'm actually okay with it because I like that it allows for, I'm going to use the word elasticity in claims. So if somebody needs a Hoyer lift, if somebody needs some type of assistive technology, if somebody needs video relay, for sign language interpretation, all of that is considered under the guise of reasonable accommodation. So healthcare providers are explicitly covered as places of public accommodation under the state human rights law. They're prohibited from discriminating based on disability, and they are obligated to provide reasonable accommodations. They are obligated to provide assistive technologies, auxiliary aids and services, and they are required to engage in barrier removal. So all of those obligations explicitly exist under the state human rights law. I know the Vocational Rehabilitation Act was recently amended for agencies that receive federal funding, and there's some explicit requirements there now, with relation to technology and accessible medical equipment. But I think you can file a colorable claim that will have merit and get the situation remedied under the state human rights law as well as the ADA.
I'm gonna do one more question before I let you move on, John. Maria's asking about if she has difficulty filling out forms because she's blind. So How does someone go about making a complaint? How accessible is it? Are there accommodations that can be made?
Absolutely. So if somebody needs an accommodation to file a complaint, they need an alternative format. They need to do it over the phone, in person. Because of a disability, they need an accommodation. We are quick to provide it. I have complaint forms in Braille if necessary, but also other forms of accommodation for people with sensory disabilities or mobility impairments. A lot of things now we do virtually, which is helpful for purposes of accommodation, but yes, we're happy to accommodate.
Great. Someone asked if the recording will be made available. The recording and slides will be made available on our website under the training and education section.
Thanks for that, Alex. I'm going to move through the next couple of slides. Blaze, do we have a hard stop at 2 o'clock, or can we go a couple minutes past?
We have a hard stop for ASL and CART billing purposes, yes.
Okay, all right. I'm going to move
Sorry.
through then. We can always circle back for another webinar, right, Blaze?
We can.
Okay.
You're always on standby, John.
Always.
Yeah.
Always. Okay. So housing under the ADA, very limited circumstances. State human rights law does cover housing providers. So if you have a housing complaint, clearly you want to be filing under the state human rights law. If you've been discriminated against or denied a reasonable accommodation by your landlord. I want to talk a little bit about service and assistance animals, and Blaze, this might be the one we want to dedicate another full hour to, because 9 or 8 minutes won't do it justice, but I'll do my best. So under the state human rights law, guide, hearing, and service dogs that are professionally trained, okay, the word is dog, and the requirement is professional training, they go where the person with a disability goes. There's no question about it. There's no reasonable accommodation analysis. So when we get these cases, and again, we're not stopping here. I have a couple of more slides on different types of animals and different types of services, and no requirement for training. So don't get hung up on, oh my gosh, if I file a complaint with the Division of Human Rights, the dog has to be professionally trained and it has to be a dog. Not the case. But if you have a guide, hearing, or service dog that has been professionally trained, that dog gets to go where you go. Okay. In housing. So again, New York State human rights law coverage for housing. We have our protections for people who use guide, hearing, and service dogs that are professionally trained. Now, assistance animals or emotional support animals that are not professionally trained are also considered types of reasonable accommodation. So here we do a reasonable accommodation analysis. So persons with disabilities that have a disability-related need for an assistance animal can ask the landlord to waive a no pet policy to allow for that assistance animal to live with the individual. So pet policies are allowable, they're not unlawful, but what you're doing here is if you have a disability and a disability-related need, so it's not just somebody who uses a wheelchair and would like to have a cat or a dog, it's somebody who has a disability-related need, okay, for that animal, can ask the landlord to waive the no pet policy. In housing, a landlord is entitled to medical documentation to support that request, to support that the person has a disability and that the need for the animal is disability related. In housing, okay, landlords are prohibited from making restrictions on the type of animal, the size, or the breed, okay? Again, they can have a pet policy, but one of the takeaways from today's presentation is assistance animals are not pets. So you may have a pet policy that says only certain sizes are allowable or certain breeds are allowable. An assistance animal, you cannot restrict the size or breed of the animal for somebody with a disability who has a disability-related need for the animal. Now, here's where we have our New York State human rights law and the ADA and the Fair Housing Act. They all kind of intersect here a little bit. And I just want to take us through some of the distinctions. The question I find to be most helpful in understanding the content when we're talking about assistance animals and where can they go, what type of animals, where can't they go, is I answer that question with a where am I standing? Okay, so the Americans with Disabilities coverage for service animals applies to places that are open to the public, not your home. If I'm standing in a place that's open to the public, a Walmart or a restaurant or a Target, I'm not in my home. The service animal provisions of both the ADA and the New York State human rights law apply. Where am I standing if I'm in my home? Okay, now we're talking about the Federal Fair Housing Act and the New York State Human Rights Law, because as I've said a number of times, state human rights law covers housing. It can be any type of animal within reason if I'm standing in my home within reason. It can be an emotional support animal, okay? And a housing provider can ask for medical documentation if I'm standing in my home, okay? If I'm not standing in my home, I'm standing in a place that's open to the public. Now we're talking about service animals, okay? Under the ADA and the New York State Human Rights Law, I'm no longer standing in my home. I've left my home, and I'm now standing in a place that's open to the public. Service animal can be either a dog or miniature horse. Emotional support is not a covered service. And an owner can ask, is it a service animal, and what type of service does it provide? The end, okay? Can't ask for medical documentation because I'm not standing in my home. I'm not dealing with my landlord. So there's the question that should help everybody hopefully sort through some of that information. Where am I standing? Talk a little bit about public accommodations quickly here to wrap up. Provisions of the ADA and the state human rights law largely mirror one another when we're talking about public accommodations. In 2008, due to some of the good work of folks here that are on the call, New York State Human Rights Law was amended to add Title III protections, right? So that covers places of public accommodation. The one kink is the coverage of transportation. And I believe that under the Americans with Disabilities Act, transportation is more broadly covered. Under the New York State Human Rights Law, there's an exclusion that does not require transportation providers to remove barriers through retrofitting vehicles or rail passenger cars by installing hydraulics or other lifts. I don't believe that's the case under the ADA. If somebody on the call is smarter than me about that, you can let me know. But I do know that these exclusions exist under the state human rights law because I read them yesterday. State human rights law also exempts any air carrier, the National Railroad Passenger Corporation, which is Amtrak, or any public transportation facilities, vehicles, or services owned or operated by state or county or local government. So some pretty big exclusions there under the transportation provisions of the state human rights law. If you're going after a transportation provider, I think you're in better shape to proceed with an ADA claim. Title II of the ADA, right, covers state and local government entities, and they were added to the state human rights law. Can't recall the year, but a state or local government entity, you can also file a complaint against if they're acting in their capacity as a place of public accommodation. How do we file a complaint? We've gone through all this information, and I can't wait to file a complaint. We have 11 offices around the state. We have our complaint forms available at www.dhr.ny.gov. Once completed, you can mail or drop them at one of our regional offices. If you have any questions, we have a phone number, which is being somewhat blocked. Let me see if I can fix this screen here by the Zoom screen. There we go. If you have questions, you can reach us by phone at 1-888-392-3644. When you file a complaint, if the complaint gets a probable cause determination and goes to a hearing, we have remedies available we have remedies available to fix the discrimination at our disposal, what I'm trying to say. It can be an order to cease the discrimination, it can be reinstatement to a job with back pay, right? If you were without a job for a while, provision of the housing accommodation for both public accommodations and educational institutions, provision of the reasonable accommodation, compensation for monetary losses or mental anguish is also available. We can require training, we can assess punitive damages, civil fines and penalties, and also award attorney's fees. One distinction here, if you're filing a place of public accommodation complaint and you want compensation for the discrimination you experienced, you can get compensatory damages under the New York State Human Rights Law. That's the distinction between the State Human Rights Law and the ADA. I'm at our contact slides here, and I see I'm at 1:59, so we're going to get it under the buzzer. I'm sorry to have rushed through those slides. Blaze, that was my fault. I should have allowed for more time. But as I say, I'm happy to come back. I'm happy to share my contact information. So if folks want to contact me directly, my email is john.herrion@dhr.ny.gov. These slides will be shared, and so you can see it there. Blaze also has my contact information if you want to reach out directly to him. And my phone number is 741-8332. Right at 2
John,
o'clock, Liz.
well done. Thank you so much, John. I'm sorry that you had to rush. We're going to have to, get off of the Zoom here. Thank you so much to everyone who participated. I promise this wasn't planned, but John set me up to plug the DHR with John Herrion Part 2. We are going to figure that out, and we'll let you know. And I would be remiss if I didn't quickly plug that we are doing a webinar with the Office of Addiction Services and Supports on Wednesday, August 14th at 1 o'clock. More info to come in our August newsletter, which when I send you the info for the or with the recording and slides, there will be a link where you can subscribe to our newsletter if you already are not. So with that, thank you all very much and enjoy the rest of the day.
Thanks, everybody. Bye.